Hey guys, the Irish Demon here, coming to you from hospital. As you guys know, check out my live stream. You'll see what happened. Had a motorbike crash, broke a load of ribs. I don't know if I have any unbroken ones left. Broke my ankle and a few other things. But anyway, most of my videos will be starting with this message because obviously I am going to be in hospital for quite a while, and I won't be able to actually appear in my videos. But I might be able to pop in with voice from time to time, depending on how things go. But anyway, I hope you enjoyed the video. We'll catch you in the next one. Hello, folks. Welcome back. Coming at you from the sitting room. Hold on. I just need to adjust my mic volume. It's a bit all over the place today. Anyway, the hair is finally here. It's finally grown back a good bit. It's got a little bit to go yet, but yeah, I won't be making that mistake again. But anyway, folks, today it's kind of a double header. We have the first one is a sob sit, which is actually quite funny. It's a no nonsense kind of situation, so we get straight stuck into it and straight back out. And the other one is just funny. It's just absolutely hilarious. Check this out.
Mr. Little, good morning to you. State your name for the record, please.
Grand Right. First of all, Your Honor, I'm your magistrate. I would like to know, do you recognize that a man stand before you?
Stand up, stand up. Stand up to the
I'm at
podium.
the podium right here.
No, stand up to the podium.
Your Honor.
I've been out of practice too long. Accidentally muted myself again. So straight off the rip, we have, do you recognize that this is a man standing before you? And so you just know what's coming. As you can see, got a new couch. It's pretty cool. It's the special edition Beetlejuice couch. But anyway, yeah. So yeah, we'll see where this goes. You can only imagine.
All right. No, we're not gonna do this your way.
Under duress, I'm standing at your
We're gonna do this my way.
Yes, sir. We are
All
gonna
right.
do it your way.
All right. State your name for the record again, please.
For matter of record, Your Honor, do you recognize that a man standing before you?
I do.
All right. For the record, my name is Bernard Brandon Little. Not the fictional, not the all caps, but the man.
Okay. Now, indicated you wanted to make a record. I was allowing you to make that record. You indicated some things in the record.
I indicated on the record that you stated that I was a man, a live man, not fictional.
No, we off the record when you were.
No, we're on the record.
Listen,
Your
listen.
Honor, did you recognize that a man standing before you?
Listen, sir.
Your magistrate.
Mr. Little.
I'm asking you.
Mr. Little,
Yes.
you don't ask the questions. I ask the questions.
No, you don't, Your Honor. No, you don't.
All right.
You're a magistrate.
Oh God, the whole your magistrate instead of your honor thing is just silly, really. It doesn't really matter if the person is a magistrate or not; they can still be referred to as your honor. Like even now, obviously, it could absolutely be totally different in the States as it is here or as it is in Australia, where I worked in the courts. But even justice of the peace in Australia, who could preside over a few things, but for the most part, where I was working, they could preside over. Like ex parte kind of initial hearings for protection orders and things like that. So they were still your honor, you know what I mean, even though they weren't judges or anything. But anyway, look, I just wanted to kind of mention that because it's just a silly argument, really. You know what, I shouldn't be interrupting so much. Let me just roll this back first. Sorry, guys.
Okay. Now, indicated you wanted to make a record. I was allowing you to make that record. You indicated some things in the record.
I indicated on the record that you stated that I was a man, a live man, not fictional.
No, we off the record when you were.
No, we're on the record.
Listen,
Your
listen.
Honor, did you recognize that a man standing before you? Your Honor.
Listen, sir.
Your magistrate.
Mr. Little.
I'm asking you.
Mr. Little,
Yes.
you don't ask the questions. I ask the questions.
No, you don't, Your Honor. No, you don't.
All right.
You're a magistrate.
All right, listen.
You don't have the authority. You
That's
don't have
it.
the authority, Your Honor. You're a
Listen,
magistrate.
listen,
You don't
sir,
have
I'm
the
not gonna
authority.
keep going back and forth with
You're
you.
not going back and forth with me.
Put him out.
Yeah, put his ass up.
I don't need your comment either. Whoever made the comment. All right.
Now, just to say this, right, for and on the record, obviously, I get why, they would want to boot these guys out, right? Like, I'm not against that at all. They're I get it. Everybody should, have an opportunity to have their say, right? I'm all for that 100%. But what these people tend to argue aren't things that really a judge can resolve, right? A lot of them are arguing issues of law, but at the kind of, the higher level, essentially. You need to be going to your legislature or your House of Representatives, depending on what country you're in. So, like here, for example, like I know in the States, the Senate is incredibly powerful. Here in Ireland, the Senate doesn't really have a whole lot of power. It's our version of the Houses of Parliament in the UK, the Dáil. They're the ones with the power. So you need to go to those people. A lot of what these lads are arguing here. So I think that is in the interest of fairness to everybody else in the court and getting through the day and not putting up with this stuff. Definitely booting them out is probably the way to go, right? Now, there is the argument that it's using this kind of authoritarian power to do that, but that's not the time and place. You have, especially in the US, above most other countries, you have the right to air your grievances, right? And I'm 100% behind that, right? Whatever it may be, however silly it may sound, I'm 100% behind people having the right to air their grievances, right? With the judicial system or whatever, anything in the public. It could be as simple as somebody feels strongly that chicken nuggets should be banned outright and take that to the highest level, the highest powers in the land. I stand by their right to do that. I think that's important, but this isn't the place to do it. And so, yeah, kicking them out is probably the way to go. Shutting them down, kick them out, and they have every right to go deal with it in the proper forum. On the other side, though, I kind of wish they didn't kick them out because then we'd have a lot more fun watching this all unfold. So anyway, the guy that piped up, I think, right? So I was listening to this video, not watching it. Somebody sent it to me this morning while I was out cutting wood, and it is so hot outside. I mean, it's so humid here right now. It's ridiculous. I knew when I woke up this morning and the ground was wet and it was really warm. I was like, it's going to be a bloody rough day. And nowhere in Ireland has air conditioning because we don't really need it, 363 days of the year. So it's hot as balls, basically, is what it is right now. So I was kind of glad to come in listening to this video. I said, feck it, I better come in. I got stung on the face by a bee yesterday when I was on the bike, and it hurts like a bee. So, yeah. Anyway, so I think the guy that piped up that the judge was talking about right there is the guy who's next. And somebody else pipes up. It's quite funny. Check this out.
So get out.
You're refusing me?
Get out.
You're refusing me, Your Honor?
Get him out.
Sorry, I thought he was already gone at that point.
Did Mr. Garrett already travel?
Yes, he did.
So that's gone. How was the trip?
Oh, it was great.
No alcohol, right?
Well,
Wrong answer straight away, bud.
And no, and not on my part.
Ah, man. That didn't start out too well, did it?
No.
I got some interns here that are just looking like that didn't sound good.
Well, basically, it was
I
no.
got a seasoned lawyer here sitting there, and I didn't feel that sounded good.
Well,
Mr.
let me
Let me ask you one more time, since you already answered. Have you had any alcohol in that trip?
baby. No,
Well, no. Oh, well, actually,
no,
no.
baby. No, baby, no.
Who is that talking? Shanika? Shanika? Say something now, I'm gonna put you out, man.
I'm trying to. There we go. Yes,
What's your name?
Shanika Lewis trying to fix my video.
All right, I don't need you to be responding and commentating on anything we're talking about except your own case, all right?
I ain't said nothing.
You said a lot.
No. Not that I know of. How are you?
Yeah, you make me question you now, Mr. Garrett, Miss.
Okay, so just to be fair to Miss Shanika there, right? I think what happened there is, well, we've all done it, right? Not necessarily for a court matter or whatever. You're sitting there, you're watching TV, or like me watching sports. I'm like, no, don't do that, don't do that, don't do that. You're kind of cheering the person on or like helping the person on, like in your mind or whatever. And I think that's all it was. I don't think she realized that she was hot mic there. I think that because she couldn't see herself on screen, that she probably assumed that she also couldn't be heard. So yeah, I think the best thing to do if you've got Zoom open in any capacity is just keep your mouth shut and your clothes on. That's the other thing I've seen happen a lot on Zoom.
Maribel, what's going to go on with this?
Okay, so one of the things is that Mr. Garrett does have a speech impediment if you listen to him just in regular conversation. Yeah.
No, that wasn't. No. I can understand he's got it, but that was not anything to do with any speech impediment there. Go ahead.
Because I deal with them. So let me give you the background, the reason why we're here, right? If you look through the file, before you allowed him to travel, you say that he had missed a drop date, right? Now, I asked Mr. Garrett because did he miss that drop date? He said no, but your honor still allowed him to travel. So we are here. Did you wanted him to test after he got back? And he did do that. So, your honor, we're here because of those particular dates. You also did a show. You have a show pause for the 25th because you said that he didn't test. Mr. Garrett told me that he did test. What I think happened was they sent the stuff to Judge Bryan courtroom and not yours. Because I asked him, he said that he tested. And that's all I can do, your honor, as an officer of the court, is ask him if he tested. And he said he did test. He has the name of the person he tested with. And maybe there's a mix-up.
All right. Well, we're gonna get the file now. I don't see a file. Mathis is going to try to discover that.
So if I could, just on the record, Mr. Garrett.
Yes.
What is the name of the guy that you tested with? Just the name of the guy. That's all we need.
Okay. I tested with Probation Officer O'Driscoll, and she has the test. And I came down there this morning and tested again too, but I tested with the Probation Officer alert.
Okay. And what was the name? So you tested with O'Driscoll and who else?
Yeah, it was O'Driscoll the day that the judge said that I didn't show up to test. And the first day that I showed up to test, the sirens went off inside the courthouse.
We don't need all that. Just the person you tested with.
I love this lawyer. Sorry, no, real quick before the judge goes off here. I wonder, is that lawyer any relation of Judge Marable? Do you remember that guy? I really liked him. He was kind of cool. He kind of reminded me of what's your man's name? That famous writer. Oh God, I can't think of his name. It'll come to me. If you guys think of who I'm talking about, let me know. He stayed at the Imperial Hotel in Cork City once upon a time. Not the judge, the writer. So if anybody knows what I'm talking about, let me know. I know that's a bit out there.
You're gonna hear it now. The first day you went and tested, the sirens went off in court, and then you couldn't test. Is that what you're gonna tell me?
I came back and tested with O'Driscoll.
No, the first day the sirens went off in court.
Yes.
Right? And then that day the sirens went off in court, you were supposed to test, right?
Yes.
And that day, because the sirens went off in court, you couldn't test. Is that what you're saying?
Yes.
No, he came back and tested.
There it is.
I tested already.
He came back and tested, John. You're not letting.
I understand that, but we were talking about a mistest, right? And that may be the reason why the test was missed. And I'm not here right now to. Okay, I have the file. Can we get O'Driscoll and I'm not trying to catch you up. I'm trying to figure out exactly what the steps are, and that would be a good reason why you didn't test that day. Moving forward, that's the question.
Okay, well, after this particular incident, you know, he is going on probation with Judge Bryan, because in this particular case, he had a DUI that they never did charge. He was arrested and it lingered. So the DUI that you have is an older DUI. And then years later, he has one in Judge Bryan that we have pled to. And he's going to go on probation with that. We did have an offer in this particular case, and I do believe that we are going to take the offer in this particular case.
Okay, what is the offer?
Impaired. He would plead to impaired.
So is that operating while visibly impaired or operating
Yes.
while intoxicated?
While visibly impaired.
And then is he gonna take the plea today?
Your Honor, today was a show cause. You have it down for a show cause.
Well, what do you want to do? You want to resolve the case, or you want to wait till another day?
Well, if we can wait till another day, I just want to resolve this issue first.
All right, we're waiting on Ms. O'Driscoll and Officer Lurch, both of them to come in. We're just contacting them right now. We'll pass the matter.
I
Give
did
them
talk,
opportunity to come on.
I did talk to O'Driscoll. She said she signed the Daimlers.
All right, let's pass the matter. Is that today's results?
That's what done,
Yes.
yes.
Yeah, you couldn't restrain himself, I guess.
So, Your Honor, you're going to send Mr. Garrett to drug treatment court?
Absolutely.
Okay.
Yeah, I asked him, I felt he had an issue when he had the 2 cases, and I think he had some other alcohol related offenses, but I mean, that's. All right, anyone
Your
else?
Honor, this is Attorney Marable, and I have a motion to suppress that's going to be heard at 12 o'clock. With Mr. Garrett, we want a trial date with Mr. Garrett.
No, well, he's not going to plead guilty?
No, he's not. We want a trial date because I believe there's some issues with this particular case, and we also want a jury trial date.
Let's go back on the record. Let's go back on the record with Mr. Byron Leon Garrett. Mr. Torres, put your name and on the record and your appearance on the record, please.
Yes, Your Honor. John Torres, Treatment Court Coordinator for the 36th District Court.
All right. So it's my understanding that he does not want to, like I say, this will be a matter of if he gets found guilty, he's going to go to treatment court anyway. Do we have a jury trial date? Now, what about this allegation of drinking? What are we going to do with that?
Do you want to have a hearing on it? I mean, he tested positive, so I guess he's going to plead guilty to that one. To that. Yes.
Do you want a hearing on that, or to contest it, or do you want to plead guilty, or what do you want to do with that, Mr. Garrett?
Can we have a hearing? Are we going to have a hearing today? We're going to set it for another day, or what?
We're going to set it for another day.
Okay, let's have a hearing. But we need a jury trial day.
All right, right now I'm upping his bond though. I'm adjusting his bond. You're gonna be testing now 2 times per week, sir. All other bond conditions will remain the same.
Okay. Do you understand that, Mr. Garrett?
Yes.
You have to test twice a week. Please test.
Okay, I will.
Jury trial is gonna be August the 5th at 9:30. Any motions? You say you have a motion, is that correct?
Oh, I don't believe I have a motion, but we can set a motion day.
25th of July. Motions due. And further, have a very good day. Best of luck to you all.
Thank you.
Thank you. Alrighty then. Yeah, that was kind of a weird one. I mean, it's obvious that the guy was drinking when he was on the trip. I don't know why he admitted to it. I mean, you know, being brutally honest, I suppose there's nothing wrong with that. But like, you know, it was like, maybe kind of like, in fairness, props to sorry, I'm so tired, by the way. I really am sorry. I've been on fumes for the last like 3 or 4 days, and I got really bad hay fever, which doesn't help either. But anyway, yeah, no, props to the lawyer for using the guy's speech impediment, but it didn't work. I mean, that wasn't a stutter. That was I said the wrong thing moment. But anyway, folks, thank you so much for joining me. I hope you enjoyed this video. If you did, make sure and hit that thumbs up, and we will catch you all in the next one. Slant you off. Now, somewhere out there in the Amazon rainforest, there's a massive tree who's existed for hundreds and hundreds of years, and whose sole purpose at this present time is to create enough oxygen for this man to spew the nonsense that you're about to hear. He needs to go find that tree right now and apologize to it. We got a soft sit here in Judge Simpson's court. Let's have a look. I hopefully have figured out and balanced my sound properly, because I know that's been a bit of an issue, but we'll see how it goes. So let me know in the comment section if it's any better. Here we go.
Thank you, Your Honor.
Thank you, sir. Okay, here we go. Court does call the case of the People versus Daniel Magoo.
It sounds a little bit low on my end, so I'll bump it up a little tiny bit. See how this goes.
Good morning, Your Honor. Ashley Lottie for the People.
Sir, state your name.
I'm here on a special appearance, Your Honor. Magoo is Easy Elastical Trust.
Mr. Magoo.
Registered in Jackson County. On case number 2522246.
Okay, is your name Daniel Magoo?
Your Honor, that is the name you seek, and it is copyrighted and trademarked.
Okay, very well. Mr. Magoo, are you represented by an attorney, or do you wish to be represented by an attorney on these matters?
I am not.
Do you wish to be?
Nope. Not at this time.
Let me then do this. You have 2 cases before this court, one being the case ending, well, let me get the full case number 25 F4 0523. In that case, sir, the complaint does allege that on March 27, 2004, you committed the offense of operating while intoxicated. Do you understand what you're charged with, sir?
I do not.
You do not understand
There is
that?
no eyewitnesses or corroborating witnesses at all.
I'm not asking whether or not the proofs are there. Do you understand what you are charged with?
I do not.
Do you understand the notion of drunk driving?
I do not understand how I could be
We've been
charged with
through this
something without a
before on
witness.
Your other cases when you represent
what you were
yourself,
asked,
so we'll
dude?
just do it.
Are you talking about the
same way.
case that's in federal court right now,
You
Your
are
Honor?
before a complaint in that case for a charge of operating while intoxicated, third offense. Because it's a third offense, that is a felony. It is punishable by up to $500 to $5,000, up 1 to 5 years incarceration. The court can order probation, 30 days to 1 year in jail, or at least 48 hours must be conserved consecutively. The court can also order community service, rehabilitative programs. The court can also order your vehicle immobilized, can order you to pay the cost of the prosecution, as well as the cost of any emergency governmental services.
As I am here and as a trust, Your Honor, I am here in exclusive equity.
You count 2 on that complaint is the charge of operating while license suspended, denied, and or revoked. That is a misdemeanor punishable by up to 93 days in jail, $500 fine plus court costs, and your vehicle could be subject to immobilization.
My license is
Count
canceled,
3.
not suspended or revoked. It is
Count 3
canceled through the state
on
of
that
Michigan.
complaint
Canceled.
is the charge of escape from lawful custody. That is a misdemeanor punishable by up to 1 year, a $1,000 fine.
I was never arrested or read any Miranda rights accordingly.
Given that the defendant is talking in English, that he understands English, understands the nature of those charges and what he's charged against.
So malicious prosecution by
wishes to
Washington County
represent
prosecutor as
himself.
usual.
Sir, there is great peril in representing yourself. You will be held to the same standards as anybody apply or for.
This is a matter under the
Not
Eastern District of
assist you
Michigan
in
Federal
any
Court.
way, or
Case
show
number
you any
2511226.
favoritism because you were not represented by counsel. I would further indicate, sir, that at any point during these proceedings, if you wish to be represented by counsel, you can make that request to the court and counsel would be appointed to represent you. Because of the defendant's conduct in the past in not acknowledging the court and what the court is saying, the court does make the presumption that he does speak English. He understands that. I would further state on the record that Mr. Magoo has been through this process before. He does understand that if he does wish to be represented by counsel, the court would give him counsel or would have counsel appointed to represent him in this matter. In the case 25F30979, in that case, sir, you are before a complaint that alleges that on or about July 3rd of 2025, count 1 is fleeing and eluding 4th degree.
Added on by the
Police
prosecutor's
officer.
office after the
Sir,
fact.
that is a felony, punishable by up
Malicious
to 2 years
prosecution.
incarceration and a
Maybe you did it
$2,000 fine
afterwards,
plus
though.
court
That's why
costs,
they added it on.
mandatory suspension by the Secretary of State.
My Secretary of
2
State, anything
is
is canceled. I have no contracts with the state of
vehicle.
Michigan.
That is a misdemeanor
This
charge.
is a matter of trust, Your Honor. This is a matter of trust. I am protected under a
90
trust.
days in jail, a $100 fine plus court cost. Count 3 on that complaint alleges operating a motor vehicle without security. That is a misdemeanor, not punishable by not more than 1 year incarceration and not less than $200 nor $500 fine plus court cost. Count 4 is operating while license suspended, denied, and or revoked. That is a misdemeanor.
All of my registrations are
By
through
up
the
to
federal government.
days,
I have federal
$500
government
fine
registration.
plus
I do
court
not have
costs.
contracts with the
Vehicle could
state.
be subject to mobilization. Count 5 on that complaint alleges refusal to obey refusal to.
I have an international driver's
Police
permit.
officer. That is a misdemeanor punishable by up to 90 days, $100 fine plus court cost. I would indicate to the defendant the same admonishments regarding the perils in representing oneself that I stated in the other case also apply to this case.
Were you served your
And that
notice
if
and
the
summons
defendant
yet, Your Honor?
wishes to have counsel appointed, the court would consider or would appoint counsel to represent him in this matter. And he apparently wishes to proceed.
Were you served your notice
Having
and summons
notice
for federal
of
court?
the charges, sir, do you wish to still proceed without an attorney?
I just want to know, where do you
Do
get your
you
powers?
wish
Are
to
you an Article
proceed?
3 judge or an Article 6 judge? Where
Do
are your
you
vested
wish to
powers? Can you
proceed
answer
without
that?
an attorney?
You can't even answer
look
me
it
what your
up.
powers are.
You can look it up.
No, you guys disconnected my access to any kind of law library or anything. You are an Article 6 judge under the Michigan Constitution. You have no authority to deprive me of my
We'll
rights.
see how much authority I have. I will assume that you wish
This is
to
a matter
proceed
of
without
trust.
counsel.
Shots fired.
I will assume you wish to proceed without counsel and that you will wish to continue to proceed.
Practicing law from the
until you
bench.
Inform the court otherwise. Ms. Lundy.
Thank you, Your Honor. Is the court completed the arraignment for the record at this time? on both
Well,
cases?
he had been arraigned. I was just admonishing him of the perils of representing himself and that it requires in part that I let him know what he is charged with. And I've read them kind of in fully, more so than I would have because he refuses to acknowledge those. So I am satisfied that he now knows all of the charges that are against him.
Thank you, Your Honor. The people would like to be heard on bond when appropriate.
All right. What do we want to set this for? Do you wish to have a preliminary examination, sir?
This is a matter of a federal matter now, Your Honor, under case number 2511226, under the Eastern District of Michigan, under the Honorable Mark A. Goldsmith and Magistrate Judge David R. Grand.
Do
This
you
is,
wish to have-
this is,
do you
this,
wish
there
to
is
have a
no,
preliminary
there is no proceeding here, Your Honor.
There is no proceeding. Oh, there's a proceeding.
Well, malicious prosecution is what the proceeding is.
Okay, very good. Do you wish to have a preliminary examination?
There's no proceeding, Your Honor. This is a matter that should be stayed and
What is
dismissed.
people's position on whether or not we should set this for a preliminary examination or adjourn the probable cause?
Your Honor, I don't know if the defendant has received all discovery in this matter as he is representing himself, so I would request a probable cause date, potentially.
Because you've got to send it.
I
Yeah,
think-
and who restricted my
So,
phone
probable
calls?
cause Conference, you know what? You're gonna have to stop interrupting. I will give you an opportunity. You've been before me before. I will give you an opportunity to say whatever you want to say. But I'm not gonna have you interrupt me, and I'm not gonna have you interrupt the people when they're talking. As long as you were saying.
Thank you, Your Honor. I have to there's video evidence in addition to the paper discovery. I've got to make arrangements with Lieutenant Arnett to work on that. So it may take just a bit longer. I would potentially look at the 7th, maybe, if the court would have entertained that. And then I will wait to be heard on bond when the time is appropriate.
I will adjourn the probable cause August 7th, 2025, 9 a.m. As the bond.
Your Honor, I've been reviewing ex jail and I wanted to double check if the defendant had been arraigned. It's not clear to me from a couple of different things, but it does appear that he has been set with a $10,000 bond in 25 F30979, as well as 25 F40523, each $10,000.
Yes.
Your Honor, I do think it's important that the court have some additional information, and I would have to ask the court to revisit the issue of bond. First and foremost, I think it's important the court know that the facts alleged in the newest case, the 25 F30979, it does include the fact that the Michigan State trooper who pulled the defendant over noted in his police report that the defendant had a license on his vehicle that indicated he was a diplomat and that he refused to identify himself. He refused for quite a bit of time. Additional units had to be brought to the scene of the sheriff's department in order to, for lack of a better term, deal with the situation. And ultimately, they were able to identify him as the defendant, Daniel Magoo. The concern with that goes along with the other case, which is an OWI. It is charged as a third. I will note that it is a true fourth, to the best of my understanding. So there does appear to be an alcohol problem going on. And I also think it's important for this court to know, because I don't know that the court knows, the defendant has a third new case, telecommunications malicious use with a domestic relationship, that is currently pending as well. He's also been set $10,000, 10% in that matter. But I think
Where is that case out of?
that case is out of 14B, Your Honor, before Judge Washington.
Of co-defendants with the federal case that you guys are both in, and this is a conflict of interest as both of you guys are defendants in my federal case.
Go ahead.
I also understand, Your Honor, that there is a municipal case out of Canton Township that was set for a jury trial in April of this year, where the defendant failed to appear. And there were jurors, there was a veneer that had been brought in. And I bring all of this up to say, Your Honor, that the people are concerned about the defendant's ability to remain law-abiding, because I'll also note for the record that at the time that the new resisting, obstructing, fleeing, eluding case and the telecommunications malicious use case came up, he was in bench warrant status before Judge Slay, is my understanding, for refusing to come after the case here had been bound over, refusing to appear in person. I say all of that to say this: I do think that $10,000 is too low. And I also am going to request a scram tether, because this is an OWI fourth alleged, as well as a GPS tether, given his history of failure to appear and failure to comply with court regulations. Thank you, Your Honor.
Is the bench warrant before Judge Slay still out?
She has bond denied in her case now.
His bond's been denied in that.
Yes, that's correct, Your Honor.
Got it. Anything you'd like to say?
Anything to do with any contracts with the state of Michigan are void ab initio for a matter of law, as I have an canceled driver's license and I have an international driver's permit. And that also relates to the Canton case that they're trying to stick me for a driving unlicensed suspended citation, in which that I have an international driver's permit, making it also void. All of my matters, including the vehicle that I'm registered under, are registered to the federal government, not the state, under the Federal Motor Carrier Safety Administration. All of these charges are frivolous and a part of a long pattern of malicious prosecution by Ms. Londy, the Washtenaw County Prosecutor's Office, and quite frankly, you, Your Honor.
Well, the judge isn't the one prosecuting you. You know, like, A lot of these guys make that
Hearing
mistake.
argument regarding bond, the court does believe that it was an abuse of discretion, given the circumstances of this defendant, to set his bond at the $10,000 figure. After hearing argument, viewing the file, the court does believe that not only does the defendant pose a risk to the public.
No
I also
victims.
do believe that the defendant is a risk of flight, given those circumstances, and has indeed, or at least is charged in this case, refused to obey or fled and eluded.
That was added on afterwards. The
officer.
police officer did not report that
Those
at all.
reasons the court, given those circumstances, would in each case raise the defendant's bond, grant the people's motion. Defendant's bond in each matter is set in the amount of $50,000 cash period. Thank you.
The tenders I requested, if he is able to post, Your Honor.
I will.
Thank you.
Thank you.
Damn. Just want to see if he says that and going out. The head shake.
If everybody doesn't mind, the court's going to take a very brief recess, and I will come back and we will finish them.
All right.
I could kind of understand why that guy, oh God, it's painful. It's the same arguments over and over again. Like, have you ever noticed with these guys that it's never very simple cases, right? Like sometimes it could be something really simple, but like it's always, you know, whatever about the driver's license, okay? I would consider myself, you know, kind of a soft libertarian, okay? But I do believe that driver's licenses are important because, you know, we need to be able to be comfortable in the knowledge that the other users of the road along with us know what they're doing to some extent. Now, you might argue that having seen some of the driving out there these days, that, you know, where did they get these licenses? Like back of a cereal box or what? But you know, even the licensing laws here in Ireland are pretty strict, right? So, you know, you get a learner's permit, and in my view, you should be able to then go and do a driving test. And if you are proficient in driving and you can pass that test, then you're good enough for me, regardless of how long you have to remain on that provisional or learner's license or whatever the case may be. But here in Ireland, you have to be on it for at least 6 months, which I can understand. You know, you have to have an accompanying driver and it gives you 6 months to get experience. You also have to go and do 12 lessons. Now, there's for and against that as well. It's incredibly expensive. But then to top it off, there's also an incredibly long waiting list for driving tests here in Ireland at the moment. So if I had my provisional license today and I hit the 6 month mark, I can then apply to go and do my driving test. And you could be waiting up to a year to 18 months, depending on where you are in the country. In the meantime, if you get stopped by the cops driving without an accompanying driver, guess what? You're getting a lot of trouble. They take your car, they take your license. It's really, really strict. A friend of mine moved over from the States. She's been living here for over a year. She's been driving in the States on a full license for like, I don't know, 60, 70 years, something like that. But here's the thing. She comes here. She's allowed to drive here legally on that US license for 1 whole year. She can't transfer that license for an Irish one the way somebody from Europe or the UK or Australia can. She has to go through the process of doing, you know, provisional license. She has to go do lessons and then has to go do a full driver's test. I disagree with that because I'm thinking, okay, if you think she's safe to drive for a whole year, her first year as well, which is arguably the ropiest one because we're on the correct side of the road, etc., and then all of a sudden she's not safe. Like it's little things like that I get with the sob sits. But then when you come to the likes of driving while intoxicated, right? Like that's not a matter of law or this book says this and this book says that. It's a matter of, okay, you could very easily kill somebody or yourself, as people do every single day, drink driving. So, you know, I'm against that. I'm like, okay, you need a license and you need to not be drinking alcohol while you're driving or, you know, immediately before you drive. And so, yeah, I'm on side with that. But in any event, these guys, they argue these silly points in court, and it's just not the forum for it. The kind of change in government or the change in the legal system that these guys want requires essentially massive, massive change, right? So how is that achieved throughout history? Usually through revolution, be that social revolution, be it political revolution, be it armed uprising, whatever the case may be. That's generally how you change a whole system of government. And even if you just look in the last I don't know, within the last half century. You know, we saw huge countries, massive countries, go through these massive revolutions. You had the Maidan situation in Ukraine prior to the current war over there. You had the Iranian Revolution, Afghani, Iraqi, Syria. You have all of these countries, these massive countries, hundreds of millions of people who decided as a collective, I'm done with this. I'm moving on from this system of government. Does it always work out? Absolutely not. In fact, usually you just go from, you know, from what is it? From the pot into the fire? What's that saying? Out of the frying pan and into the fire? I think it is something like that. You get what I'm saying. Like grass isn't always greener kind of thing, but sometimes it does work out. And a lot of these guys don't understand how lucky they are to actually have the system of government and the system of law and courts that they have in the United States. I know a lot of people think that freedoms are being eroded in the States. And to some extent, you could argue that that is the case compared to, say, 50 or 100 years ago. But if you look at it compared to the rest of the world, right? Like here in Ireland, we have a fairly solid level of freedom for the most part. We're in a good situation. We don't particularly have the right to defend ourselves, which is madness in my book, considering the kind of people that we are. We have a history of defending ourselves in many ways. And also our freedom of speech here in this country isn't to the standard that it is in the States. There's certain things that I can say that aren't fighting words, etc., or threats that could get me in a lot of trouble. Same in the United Kingdom, you say a certain thing about certain groups of individuals, and if it's construed a certain way, that's it, you're done. You could go to jail. People do go to jail for it. Same in Canada. You look at Japan, right? In terms of Asia, Japan is probably, I suppose, the most Western in a lot of ways. But then you look at their system of law. The strike rate for prosecution in Japan is approximately 99.9%. If you get accused of something in Japan and go to court, chances are it's 99.9% that you will be found guilty. That's just the way their system works. It's stacked against you. You've got no chance, right? So you're lucky that you can go and actually fight these things in the US. Here in Ireland is the same. You can fight, you know, these kind of things if you don't like them. But whinging to a judge isn't going to change anything. Whinging to a judge is going to affect you and you only in the immediate. Now, you might say it's his soapbox. He gets to jump up there and say what he wants to say to maybe change some hearts and minds. But his behavior, his smug attitude kind of beats that back down. It stops that from being achieved. And with the way the world is now, the easy access to media that we all have. I mean, look at me. You know, 71,000 subscribers at the moment, and I'm able to just sit here, some random Irish lad in a cottage in the south of Ireland in the mountains, and I'm able to talk to you, thousands and tens and hundreds potentially of thousands of people, arguably potentially millions of people, immediately about my thoughts. So why go into a courtroom and argue stupidly and smugly, make yourself look like an idiot and achieve absolutely nothing other than basically getting your bond raised and guaranteeing that you're going to spend a few extra nights in the clink. So there we have it, lads and lassies. I hope you enjoyed that video. These solves, they're the gift that keeps on giving. Anyway, folks, thank you so much, and we will catch you in the next one. Sláinte.
Crane. Mr. Crane's coming up. Hey, you, Mr. Kazicki?
No.
Mr. Crane, do you have counsel? Was that you, Mr. Barron?
Your Honor, Todd Barrett, I did speak with Mr. Crane prior to the court calling the case today. I think that at this time, Mr. Crane's probably best served proceeding on his own. There are some constitutional arguments that he's raising that I don't think as a member of the bar I can.
Oh, is he a sovereign citizen?
He's making some sovereign arguments, yes.
Okay, I have very little patience for them. I will let you know that, sir. So, okay, tell me your name.
My name is Randall Crane. That's a living name, not a corporate fiction.
So you're a real person named
I am
Randall
a real
Crane.
person. Okay. I'm
Okay,
here.
no, listen to me. Sir, you're here today because you have some charges against you. All right.
I'm challenging the court's jurisdiction.
Okay, well, denied. Your motion's denied. I have jurisdiction to the Constitution of the state of Michigan. What's your next? I'm not arguing with you, sir. I have jurisdiction. So
You have to provide subject matter jurisdiction as well
Okay.
as personal jurisdiction to me before these can proceed.
Okay, your motion's denied. I have jurisdiction under the Constitution of the state of Michigan. What else? What else?
You do not have jurisdiction over the national.
I just said I did.
No, you don't.
All right. All right,
Okay.
so sir, do you want to proceed on these cases and talk to the prosecutor? Don't look on your phone while you're talking to me. If you
My
don't
notes
know-
are on-
No, you listen to me. If you don't know your sovereign citizen arguments well enough to come up here and say them, I can tell you can't have I can tell you can't have a phone in here. I want you to listen to me. You're here today on misdemeanor charges, no talking. You're brought into court, you've already been arraigned, you have a charge of interfering with police officers in the, while they're doing official business. That's a misdemeanor punishable by up to 90 days in jail and a fine of up to $500. You also have a civil infraction for operating, using a mobile electronic device, first offense, while operating a motor vehicle, a charge of no proof of insurance. Those are both civil infractions. Civil infraction for no proof of or no registration in a motor vehicle. So those are the charges against you, sir. I'm going to tell you the rights that are actually real rights that you have in this court. You have a right to an attorney appointed at public expense if you are indigent without money to hire an attorney, and if the offense charge requires a minimum jail sentence or the court determines that it might sentence you to jail. The appointing authority will decide if you are indigent and appoint counsel if you are eligible. You may have to repay the expense for an appointed attorney. You may contest your ability to pay the ordered fees if the court attempts to collect any cost for an attorney, and the court must determine your ability to pay at that time. If you have a trial, you have the following rights. You have a right to, this is how trials work. You have a right to call witnesses to speak for you at trial, and you can get an order signed by the court to require witnesses to come to court. You have a right to see, hear, and question all witnesses against you at trial. You have a right to be a witness for yourself or to remain silent. If you chose not to be a witness on your own behalf, the prosecutor could not comment on your refusal to testify. Lastly, you have a right to be presumed innocent unless you are proven guilty beyond a reasonable doubt. If you enter a plea, obviously you'd be waiving those rights. You also have a right to be released on bond. Now, it looks like you previously stood mute on these charges, so you're here today for a pretrial. You have a few options, sir, under the law of the United States, the Constitution of the state of Michigan, and statutory law and court rules in the state of Michigan. You can either retain your own attorney to proceed on this case, or you can have a pretrial with the prosecutor directly and try and work out an agreement, or we can set it for a jury trial. Okay, those are your options. You can get an attorney, use a court appointed attorney, but you understand that attorneys have an obligation to follow the law and not make frivolous arguments, which is what you want to make today. And if an attorney makes those arguments on your behalf, I could sanction them. So no attorney on this green earth is going to come in and make the frivolous arguments you're making on your behalf. Or you can speak to the prosecutor, or we can just set it for a jury trial. Out of those, I don't want to hear it. I want you to pick out of those four options what you want to do. Hire an attorney, speak with court appointed attorney, talk directly to the prosecutor to work towards a resolution, or set a jury trial. Pick.
Let me ask you a question.
No, I asked you a question and I'm telling you to answer it.
And I have the right to understand my rights and understanding.
Sir,
exactly
here,
what-
can you hand him this form? These are your constitutional rights I just read to you. Why don't you have a seat? You have a seat, read your rights, and I'll call your case back up.
I am asking for you.
Have a seat right now
What
and
was
read
your
your
oath of
rights.
Office.
Have a seat.
Have a seat right now and read your rights, sir. If you
I
don't
read-
understand them, read them.
I move for this court to dismiss.
Have a seat.
Okay, next case. This is 2514260T, the People versus Diana Buchanan.
Good morning, Your Honor. James Kazik.
All right, we're coming back up. This is 2509380M, the City of Taylor versus Randall Crane. Mr. Crane, you want to come back up? Mr. Crane, did you have a chance to go over your constitutional rights that I provided to you?
Yes, I understand my constitutional rights.
Okay, thank you, sir. So at this time, I gave you four options. Would you like to retain your own attorney? Would you like to speak with House counsel and have an appointed attorney? Would you like to meet directly with the prosecutor? Or would you like to set the matter for jury trial?
I'm going to be requesting for an order of change of venue.
Denied. Anything else? There's no basis for that, sir. So I'm asking you, we'll just set it for a jury trial, okay?
I have to understand everything in regards to my case.
Sir, I gave you your constitutional rights so that you could review them. I also gave you the attorney,
I understand
a
that,
court-appointed attorney to go over those rights with. So I gave you an opportunity to understand your rights. I'm not going to entertain, listen, I'm not entertaining your sovereign citizen arguments because they're unfounded and they're not legal. There's no legal basis for them. So I'm not doing it. So now I'm asking you, out of the 4 choices I gave you, which one would you like to do?
I am required to understand everything in regards to my case,
Okay.
including subject jurisdiction matters.
All right,
as
well, you
as
could do your
personal
research. I'm
jurisdiction.
setting this for a jury trial. We'll see you back for your jury trial on November 14th of 2025 at 9:00 a.m. I really recommend you retain an attorney prior to that date, sir, because I know I'm going to tell you what you're not going to do, waste the citizens of Taylor's time with your nonsensical arguments. You're going to come in, you're going to try your case. Again, if you want to talk to House counsel, you could do so. All
I'm
right.
not wasting the city of Taylor's time.
Okay, good. We'll
Okay.
see you on your trial date. Have a good day.
Arlene Gay, the defendant.
All right, and are you Mr. Beltran?
Yes, Your Honor.
All right, in defense, you said you've adopted his motions?
Yes, Your Honor.
All right, so the first motion is a motion for a special appearance under the authority of Texas Rules of Civil Procedure 120A for the divine purpose of objecting to the de facto district court's abstract subject matter jurisdiction, non-ex parte third-party waivers allowed. So let's address that motion.
Yes, Your Honor. My client's position is that that there is a defect in the abstract subject matter jurisdiction, that he has been brought into this improperly because the state would be the plaintiff, and they brought him in and are litigating that, and that there's a jurisdictional issue that the court does not have in persona or subject matter jurisdiction.
All right, is there a response, Sate?
Judge, as a criminal district court, the court does have jurisdiction to preside over any matters. The defendant has been charged by indictment with the offense of aggravated robbery, and that occurred in Dare County, Texas, and so the court retains jurisdiction over those proceedings.
All right, so Mr. Beltran, anytime that there is a criminal case that's deemed by the penal code to be a felony, then that comes to a felony criminal court. All right. And then the next question becomes whether or not a grand jury has been given evidence. You've been indicted, so they've been presented with information, right? And if it's alleged that the incident occurred in Bexar County and it's a felony, then I would have jurisdiction over the case. So if for some reason this was a case that is alleged to have happened in another county, let's say it's Hayes County or Harris County, then I wouldn't have any jurisdiction over it. Do you understand? All right. So with this case, I'm not taking any of it to be true because I have to wait till evidence is presented to me. But looking on the face of in the indictment, and I'm sure your attorney will tell you, an indictment is not evidence of guilt. It's just the means whereby a person is held over for trial, right? And so when a grand jury indicts a case, they're just saying there's enough evidence to hold you over for trial. They're not saying it's evidence beyond a reasonable doubt. And when information is taken to the grand jury or evidence, police reports or whatever it may be. In it, it has to be allegations that it happened in Bear County. In it, it has to be allegations that it's a felony. Now, if this were not alleged to be a felony, then it wouldn't be in this court. Even though it would be a criminal case, it would be sent to a misdemeanor court maybe, or perhaps even a municipal court. But because aggravated robbery, according to the penal code, is a felony, it's supposed to be in a felony court. And then if they're saying it happened in Bear County, then it would come to a felony district court, state district court that's in Bear County. And that's where we are. You understand? Is there anything you not understand about my ruling on that? All right, thank you. And then we have, yes.
Excuse me, did the court take judicial notice of the indictment in this case?
Yes.
Make its ruling, okay.
Yes.
The
The next we have new discovery of ex parte corpus trust fraud upon the court that conceals the facts that the charging instrument lacks subject matter controversy. No injury in fact exists.
Your Honor, I believe what my client meant by that is just kind of coupled with the first paragraph, that the court his position was the court didn't have jurisdiction. The court just ruled that they did. That then the indictment would not be valid in this case. So I think that's what the client is trying to say.
All right.
Did I get that right?
Yes.
Okay.
All right. So State, you want to address the issue and and if I'm interpreting this incorrectly, let me know, okay? So you are saying that the offense, that there is no subject matter jurisdiction because there's no injury by any party?
Yeah.
All right. So if you can address that.
Your Honor, this case was presented to a grand jury that was duly impaneled. They indicted the case. They returned a true bill of indictment. The indictment does comply with the penal code and the code of criminal procedure, which governs in this case. And it does allege the requisite elements for the aggravated robbery. And so it's a threat by using a deadly weapon. And so that is the harm. The crime was committed against the peace and dignity of the state, and there is an alleged complainant.
All right. So Mr. Beltran, do you understand with the charge of an aggravated robbery case, sometimes it's alleged that a person maybe pulled a knife on somebody and said, give me your money, right? I don't know any of the facts about your case. The only thing I can do is look at the indictment, right? And then sometimes it's alleged that somebody pointed a gun at somebody and said, give me your money. The way indictments work is if it is a crime in the penal code, and there's a list in the penal code of all the crimes, and aggravated robbery is one of those crimes that's listed in the penal code, and it sets out what the elements are of that. Now, you're saying that there was no injury in fact exists. The only thing the state has to do is prove the elements that are in the indictment, and the indictment has to show the offense that is in the penal code. You understand? So do you understand? You gonna have any questions about the court's ruling? All right. If there's something you don't understand, let me know. All right. And I understand that sometimes when people have been to law school, like for example, I haven't really worked on cars. So there's a little stuff I can tell you about being a mechanic, but I really don't know the ins and out of every vehicle. You understand? All right. So number 3, defendant is erroneously charged with an abstract offense. C, I don't know, I can't read that word. Something taxation. District court is criminally attempting to receive an unauthorized, colorable, no fault immunity third-party benefit in violation of the 7th Amendment. All right, do you want to address that, counsel?
Yes, I believe my client, I think it just goes back to being a a third party brought in here without abstract subject matter jurisdiction. And the fact that he was brought into this case. I believe that's it. Is that it? Okay.
All right, State, do you want to respond?
Judge, regarding, I guess, the Seventh Amendment applying in the case, or, okay,
Yes.
that is for civil suits. We are in a criminal court, and so I would argue that that does not apply here.
Mhm. All right, so the Seventh Amendment applies to jury trials that you're entitled to, and that is in federal civil cases. Here, you do have a right to a jury trial if you want a jury trial. And if you want a jury trial, I'm gonna make sure that you have a jury trial, okay? And then the other issue, let me see. I don't understand when you say, explain it to me, you're saying district court is criminally attempting to receive an unauthorized colorable no fault immunity? What do you mean by that? Because what I can tell you is I don't receive anything related to these cases. Of course, as a judge, I'm paid a salary for the work that I do, but I don't receive any funding or extra funding based upon how I resolve cases. Do you understand? Do you have any question about that?
No, ma'am.
All right, so then the other one is dishonest services that rises to constitutional tort and national security concerns, communist activity detected in violation of Title 50 USCS 841. This court now under federal questioning under Title 28 USC 1331, light of new evidence investigation hypothetical claims. All right, defense.
I'm not sure what my client means by that. I'm gonna ask him to explain it.
All right, if you could explain that to me, Mr. Beltran.
I guess what I'm trying to say there, Your Honor, is how the state of Texas is plaintiff. And they're the ones that are pursuing and to prosecuting me, which is they're one of third party.
Okay.
And I'm not, I don't, third party, I'm not sure how that works. I know how civil suits, and I know it's criminal law, but I know that, I mean, how can I cross-examine the state of Texas? How can I?
So let me explain something to you. Whenever you see cases on the criminal side, it's not individuals versus individual. Usually when you're on the civil side, if it's a marriage, it's individual. If it's civil. All right, here, the reason why it's the state of Texas is because in criminal court, it's not you versus the complainant. Whoever the complainant is in this case that you're accused of committing aggravated robbery against, yes, it's alleged to have happened that you committed an aggravated robbery against them. But the state of Texas, the way we were taught in law school, the state of Texas takes offense, right? Because whenever an offense is committed against a citizen, it's the offense against the citizen, but it's also the offense against the state of Texas. So in cases such as these, the state necessarily is not the complainant. They're just bringing the suit or the case because the state of Texas is offended that an offense is alleged to have been committed within the state of Texas, within the county of Bear. So that's why the state of Texas is listed and not the complainant. Do you understand?
Yes, I understand that. And so how do I cross-examine the state of Texas?
The state of Texas, you don't cross-examine them. The persons you would cross-examine would be any witnesses the state of Texas would call to try to prove that you've committed an offense against the sensibilities of the state of Texas. So, for example, for an aggravated robbery, they'll need to call somebody to prove that it happened in Bexar County. They'll need to call somebody to prove that it happened on or about whatever date it is. If there's a weapon used, they'll need to call somebody to prove that a weapon was used. And they may need to call a complainant to say, hey, I'm the person in your indictment. You understand? All right. Do you have any questions or any confusion? All right.
May I ask my client a question before you go on to next? Are there any other things in here? Because some of it repeats itself. Were those the main points?
Other than anything.
Or is there anything else in your motion that are different that we need to bring to the court's attention that would be different?
All right. So then with regards to that motion that's combined from page 1 to page 6, then the ex parte relief requested will be denied. Now, by denying that, that doesn't mean that if there's a jury trial, your attorney still will not have the opportunity to question whatever witnesses the state calls, okay? So that will be denied.
There is it appears to me that there was like 3 separate documents stapled together. Is that the way it was received?
Yes.
There is the next one, which is exhausting administrative relief. My client is not wanting to have that heard, right? It deals with ineffective assistance of counsel. Right, Mr. Beltran, that's not to be heard right now?
Okay, and let me explain something to you. I understand that's not to be heard right now, but what I can tell you is attorneys who are appointed to represent people, those are attorneys who are on the wheel for appointments, right? And if this is a first-degree felony, just from the face of what I'm looking at, and if Ms. Gay wasn't qualified according to the qualifications to be on the wheel for first-degree felonies, she would not have been appointed to represent you. Do you understand? And Ms. Gay, are you on the first-degree will?
Yes, I am.
All right.
So the next document is entitled Court Constitutional Notice. And that addresses antitrust violations, brought upon the court, actions of the state bar.
All right. Do you want to take these one at a time, counsel?
I guess so, Your Honor.
All right. The first is new discovery of antitrust violation lies brought upon the court. Elected state bar officials, seditious organization, are conspiring to fraudulently conceal the ultimate fact, Sixth Amendment misconduct, that the State Bar of Texas lacks capacity to prosecute a natural person. It is an improper plaintiff. All right, so with that, I can tell you the State Bar of Texas is not prosecuting you. The State Bar of Texas is more of an affiliation that attorneys are required to belong to. And we actually have to pay state bar dues every year. And when that comes around every year, everybody's like, oh my gosh, state bar dues.
Do you know?
Yes. So the state bar is not participating in this trial. Now, I can tell you as an attorney, your attorney as an attorney, and the state as an attorney, anyone who's licensed in Texas, they're required to be a member of the State Bar of Texas, and they have to pay dues to the State Bar of Texas. I think it's $265. It may have gone up. All right, so they're not going to be trying you. All right, the next one is State Bar's virtually gathered evidence, video, police reports, third party. Again, what I can tell you about that is the State Bar hasn't gathered any evidence.
Do
I
you
think I
want-
just put, I'm sorry, Your Honor.
Yes.
I think I just put that as.
All right, so do you want that heard or no? All right, and then the next one is, so to permanently prevent a false state bar, anything with regards to the state bar, do you still want that heard or no? It says objects to Texas State Bar ex parte matter waivers and fictional double jeopardy defective jurisdiction. Do you want that heard?
Yes.
All right. Defense?
My client believes that, again, that the court does not have jurisdiction, that he is concerned about his waiver of his constitutional rights. Some of this deals with what happens at trial, like hearsay evidence being admissible, being admitted wrongfully, and that he still believes he's a third party, and that there's abstract jurisdiction, and that the court doesn't have the power, I'm guessing, to rule on evidentiary issues such as 901, and that, in other words, probable cause is third party fabricated, then secretly planted and dressed up to appear that it has merit, but it does not. So he is talking about one jurisdiction and also trying to state his right to object to evidence.
All right, State, do you want to address that?
Regarding this collection of evidence, I'm not sure.
Oh, no. So, let's address double jeopardy. Double jeopardy, defective jurisdiction. So double jeopardy, if you have not been previously tried for this same offense before, that's what double jeopardy is. Basically, in a nutshell. There are certain exceptions to that. But when you mention double jeopardy is you've been tried for something before and you were found not guilty, right? And now the state is trying to try you for the same thing, even though you were previously found not guilty of it. Or either you had something that was dismissed with prejudice and they're coming back and trying to try you for that same offense. Do you understand?
Yes, ma'am.
State, has he been tried before for this same offense?
No, Judge, there has been no actions on the indictment or the indictments that are pending against him. And as far as I know, he's not been charged by any other jurisdiction regarding this.
And there has never been anything pre-indictment that was dismissed with prejudice with regards to these cases? All right. Does that address that issue for you?
Yes, ma'am.
All right, then the next one, deceitful corporate veil and trumped up judiciary immunity is fatally pierced. I do not forfeit my privileges and immunities under the 4th and 14th Amendment. What I can tell you is during a jury trial, when the state calls their witnesses, your attorney will have a chance to cross-examine those witnesses. The rules of evidence do apply. If she finds that there is some question that is objectionable and should not be answered, then she will stand up, make an objection. Normally, the objections may be hearsay, entering the province of the jury, assuming facts not in evidence. It could be relevancy. It could be 404B. It could be any of a number of objections that she can make. Once she makes those objections, I will make a ruling, and my ruling will decide whether or not the witness can answer that question and whether or not the jury can consider it. Do you understand?
Yes, ma'am.
All right, does that address that issue?
Yes, ma'am.
I think the other issues deal on the second page, deal with the state bar, and I think the courts address that.
Okay.
The other one is gross advertising negligence of the DA's office.
Okay.
And defendant being sued,
Oh, who's being sued?
the defendant.
All right. So, sir, there are different type of suits. There are civil suits. So technically somebody can be sued civilly for something. Sometimes with criminal cases, people will say, oh, it's a suit. Technically, it is sort of a suit, but it's again, the state of Texas versus whoever the defendant is. You understand?
Yes, ma'am.
All right. Do you have any questions about anything else? Okay. And then the next page, page 6, it has postscript. Is there something in there that needs to be addressed? I think it says here, it has to do with cross-examination. And then he say the plaintiff is in harmless artificial corporation. Are you talking about yourself or the state of Texas? Okay. All right. So whether or not it's a fishing expedition or corporate entrapment or a Ponzi scheme, that'll be something that will be decided during the jury trial, okay?
Yes, ma'am.
All right. All right, is there any other motion that needs to be heard?
Anything else? Any other jurisdictional arguments that raised that we have not talked about and the judge has already ruled? Anything other than
No.
All right, is there anything that you don't understand about the jury trial process? All right, so I will still give you a choice. If you want a jury trial, you can have a jury trial. If you want a bench trial, if the state agrees to the bench trial, then we can have a bench trial. As I've told you before, if the state presents evidence that proves you guilty beyond a reasonable doubt, that means each and every element, I'll find you guilty. If they don't, I'm going to find you not guilty. You understand?
Yes, ma'am.
All right, so if you still want a jury trial, Norma, is he already scheduled for jury trial? All right, so, counsel, you're still requesting a jury trial? All right, Norma, if you can put them on the, jury trial, please, and Ms. Galloway, if you confer with the defense on a jury trial date, so they're gonna get a jury trial date, okay?
Thank you, Your Honor.
Oh, you're welcome.